Good morning, everyone. Um, my name is Valerio De Stefano. Welcome to this seminar on the right to strike under international law. I'm a professor of law and Canada researcher in innovation law and society at Osgoode Law School of York University here in Toronto, and the general editor of the Comparative Labor Law and Policy Journal, which we are proud to host here at Osgoode together with my colleague, Professor Sarah Slin. This seminar is organized by the Nathanson Centre on Transnational Human Rights, Crime and Security and Osgoode Law School at York. We have convened this discussion in the wake of the hearings before the International Court of Justice on the right to strike under ILO Convention No. 87. We are very thrilled by the response to this seminar. Registration exceeded our Zoom capacity twice, and for that I want to thank Professor Barnali Choudhury, who is the director of the Nathanson Centre, Liel Gonzalez for coordination, Osgoode Professional Development for the technical support, Dean Trevor Farrell for supporting all of this, and last to my students, Elisa Music and Kay LeBlanc for their research, help, and technical assistance in transcribing this seminar. We will share the recordings and the transcription in due course after the seminar to all of you and to all people registered, and we will also publish the recordings on the Nathanson website, so it will stay there as a resource. Now, our goal today is to offer academic and practitioner perspectives on the questions before the court. The right to strike, of course, is not only about collective bargaining. In many parts of the world, is a pillar of democracy and a safeguard for the rule of law. And for over 7 decades, the ILO supervisory bodies have affirmed that the right to strike is a core element of freedom of association and that is protected under Convention 87. And that principle is now being tested before the ICJ. The case before the courts, therefore, is more than just about the right to strike. It's really about the foundations of international labor governance, the authority of the ILO supervisory bodies, and the integrity of the international rule of law itself. Each of our speakers will have about 15 to 20 minutes to make their remarks, and after which we'll open a Q&A section. For those who join us on Zoom, please send your questions through the Q&A function on Zoom, and we will select a few of those and we'll pose them to our participants. We are really honored today to have a stellar panel of leading scholars and practitioners to help us reflect on the crucial issues before the court. And so without further ado, I now turn to the first of our speaker, Papa Dankwa. Papa is the director of the Legal and Human and Trade Union Rights Departments at the International Trade Union Confederation in Brussels. He led the ITUC legal team in the case on the right to strike before the ICJ. And before joining the ITUC, he headed the legal and administration departments of the Trade Unions Congress of Ghana. He's a barrister and solicitor of the Supreme Court of Ghana and holds an LLM from the University of Warwick and a law degree from the University of Ghana. If I understand correctly, Papa will start us off by explaining how the ICJ case came about, beginning with the 2012 breakdown, of which we're going to hear about, and by also outlining the main takeaways from the hearings and what the court's forthcoming decision could mean for the future of the ILO. So, Papa, thank you so much for joining us. You have the floor. Thanks.
Thank you very much, Professor Valerio De Stefano and the Nathanson Centre on Transnational Human Rights, Crime and Security for organizing this event. I'm happy to be part of it and to be part of this stellar panel to discuss this critical issue of the right to strike under ILO Convention 87. As you said, Valerio, last week, we had the oral hearings at The Hague, at the ICJ, and it was a pleasure to work with many colleagues, many of you here also, to prepare our case before the court. I appreciate also very much the question, I think, Valeria, on your flyer, which says, what does this case mean? All right. So let me try and give a succinct context regarding the dispute and why the ILO governing body requested this advisory opinion, and then I will shut up and we will all listen to the experts. So first, the question before the court, I mean, this is a legal discussion. So let's start with that. The question before the court is the right to strike of workers and their organizations protected under the Freedom of Association and Protection of the Right to Organize Convention 1948, Convention 87? This question arose for the first time since the establishment of the Committee on the Application of Standards of the ILO in 1926. Because it could not perform its function of supervising the application of ratified conventions in 2012. And why was this? This is because the employers group objected to the detailed guidance provided by the Committee of Experts on the application of convention recommendations on the right to strike under ILO Convention 87. The inability of the CAS, as we call it, to function was an institutional crisis. It was massive, and the effect of it has continued until today. Since 2012, efforts have been made to no solution to try and address the reason for the crisis, but this has not yielded any fruit. In the view of the employers, sorry, my computer keeps blinking. In the view of the employers, not only does the convention not expressly provide for strike in its text, the right to strike is not protected under the convention, not even as an integral part of freedom of association. The employers also say that the travaux préparatoires also backs up their claim that the right to strike is not protected whatsoever under the convention. In the view of the workers, in our view, the right to strike is an activity of workers. It is an action undertaken by workers to advance and defend their interests and rights. And the right to strike is an integral part or a corollary of freedom of association and an essential means by which workers advance and defend their interests and rights. And that, we also argue, a proper reading of the travaux will show that the drafters were concerned about the level of detail that will suffice for the convention and the application to categories of public servants, and not the exclusion of strikes or the right to strike from Convention 87. And also that in any case, a huge majority of governments ratified Convention 87 after it was affirmed that the right to strike was protected under the convention. The first time this was done was in 1952 by the Committee on Freedom of Association, and later 1959 by the Committee of Experts on application of conventions and recommendations. And I will come back to that in some detail. It is important for me to start by acknowledging that we and I have a huge respect for our employer counterparts in this unique tripartite body of the ILO. But on this issue of the challenge of the right to strike, we have a deep sense of unfairness and injustice done to us. First, the Freedom of Association and Right to Organize Convention is a fundamental human rights convention of the ILO. It was adopted in 1948. It is an integral part of ILO law and ILO work on freedom of association. As I said, between 1952 to 2012, there was broad consensus that although the word strike is not written in the convention protected the right to strike. This was consensus with the employers, with a huge majority of governments. And even those governments who raised questions about the right to strike, read properly, those questions related to the details of regulation or guidance from the committee of experts, and not whether or not the right to strike was part of freedom of association or an activity of workers. And as we said in our written submissions to the court, after 1989, the employers started to voice concerns about the detailed regulation of the right as well, but not about its existence until in 2012, when they said that the right did not exist at all under the convention. And this is the legal issue. And for us, it's important to focus on that. This is the legal issue, because this is why the Committee on Application of Standards, a supervisory body of the ILO, is unable to provide guidance to governments on the scope of the right to strike in relation to their policies or legislation since 2012. And since 2012, consistently, when the issue of the right to strike has come up, you have had statements for the right to strike by the workers in meetings, and statements against the right to strike in the convention by employers, creating this legal uncertainty and lack of coherence in the supervisory system of the ILO, and undermining the credibility of the system. I talk about a feeling of unfairness, and this is also how I want to say it, that we feel like in 2012 the rug was pulled from under our feet. That's something that both of us, at least us and employers, and a huge majority of governments had agreed upon, was suddenly not there. And this is, I really want everyone listening to get this. This is it, that we agreed, we had something that protected us, protected the right to strike since 1952, at least, right? Let's just say that, at least. And then suddenly it's not there. And it's not there not because we, the workers, have done something. It's because the employers say that the committee of experts in particular was providing too much detail in their guidance to governments. What has that got to do with whether the right to strike is protected under the convention, and whether we could work together around the main concerns or the main protection that workers must enjoy under the convention? And I will dare to say as well that if it was us, the workers, who had concerns about a committee, the committee of experts, or a supervisory body, in quotes, going above what we expected to be their work, we will go to the ICJ. We will go to the ICJ. So since 2012, at least between 2012 and 2015, we pushed in the governing body that, look, this issue is such a fundamental legal issue that let the International Court of Justice address it, so that we can go back to the normal work of the supervisory system, the normal work of the Committee on Application of Standards, where both the workers group and the employers group have a privileged role of coming together to work on conclusions and providing guidance to governments on the application generally of conventions, but in this case, specifically on Convention 87. So let me come back. The ILO constituents had a coherent legal interpretation of the right to strike under the convention, and for purposes of arguments, let's say this interpretation has been applied fully since 1952, some 60 years, until 2012. And as I said, since 1959, the Committee of Experts have said prohibiting strikes contravenes Article 8.2 of the Convention. Article 8.2 says, deals with national regulation on strikes, or freedom of association generally, but because we're talking about strikes, on strikes that impair the guarantee provided under the Convention. So what we heard last week is that, from my perspective, our perspective, everyone accepts that strikes are activities of workers. Some participants even said they are not the only activities of workers, which means they are activities of workers. So broadly, everyone accepts that. A few say that the acknowledgement of strikes as activities of workers should not apply to Convention 87. We say there's no reason to exclude strikes as an activity of workers under Convention 87. So, and then a few, we say the right to strike is an integral part of the principle of freedom of association, and that is protected under the Convention. A very, very, very tiny few say, in respect of Convention 87, the right to strike should be excluded as a corollary of freedom of association. So what does the case before the ICJ mean for us? For us, the court is the only one that can address this legal issue of whether or not the right to strike is protected under the Convention. Whether activities under whether strike actions are part of activities of workers read under Article 3 together with Article 10 of the Convention. This is the only way, in our view, that we can restore legal security and legal certainty for us. This is the only way that the concerns around the injustice we feel, the unfairness we feel, that the rug has been pulled from under our feet can be addressed. And we have, as we said before the court, we have full respect for the court and for international rule of law. And this is the evidence of this was also how I introduced our speech, that a century ago, the workers, our predecessors, went to the court to also seek redress when it was necessary for them to do so. For governments, it means legal certainty on what their obligations and duties are under the Convention, which for some time now, at least when it comes to the competent application of standards, there is no clear guidance to them since 2012. And then for the ILO, the system itself needs the legal logic, its coherence and certainty regarding the principle of freedom of association restored. And this point was also strongly made, not only by us, by the other participants who agree that the right to strike is protected under the Convention. So for us, strike action is an activity of workers, and the right to strike is a corollary of freedom of association. It is regulated at the national level, subject to the limitation that the law should not impair or impede the right guaranteed. And that the preparatory document shows that there was indeed a debate on it. But as I said, it raises only 2 points. What's the level of detail? Okay. And which categories of public sector workers should be covered or not covered. And since the adoption of the Convention, states have received guidance from the supervisory system of the ILO regarding the application of the Convention in law and practice. which has included answering the question under Article 8.2. And in our view, a decision from the court will help us to get back to that, or at least give us a path to addressing this dispute that has really affected the credibility of the supervisory system of the ILO. Thank you very much, Valerio.
Thank you, Papa. Thanks a lot. And of course, I think we will go back to your presentation at the end for the Q&A. Again, if you want to post the questions to Papa or any of the participants, please do so in the Q&A section of Zoom. And now I will leave the floor to Professor Giannis Bellace. Professor Bellace is a Professor Emerita of Legal Studies and Business Ethics and of Management at the Wharton School of the University of Pennsylvania. She's a graduate of Penn and the London School of Economics, and she received an honorary doctorate of science in economics by Sydney University in 2017. Janice is also a member of the Senior Editors Board of the Comparative Labor Law and Policy Journal and serves as a judge and vice president of the World Bank Administrative Tribunal. She was a member of the ILO Committee of Experts on the application of conventions and recommendations from 1995 to 2010. So she has first-hand experience on how the supervisory system works, and she's one of the world-leading authorities on the background to the adoption of Convention 87, which I think is going to be the focus of her presentation. So Janice, thank you very much for joining us today, and you have the floor.
Thank you. In 2012, at the International Labor Conference, when at the Committee on the Application of Standards met, and Papa has described what went on, the next day I got an email explaining all this, and I must say I was shocked. Why was I shocked? Well, I could barely believe that one could say that there was no right to strike in Convention 80, implied in Convention 87. But at that point, I thought about it and said, maybe I've just assumed this. You know, I've been on the Committee of Experts for 15 years. I chaired it at the end. I was a rapporteur on Convention 87. Maybe I haven't looked at this carefully. And that's what made me go back and look. What did this term, freedom of association, mean? I mean, it's not a common term. If you went out, and those of you who are academics, if you went and asked lawyers in some other field what freedom of association means, I think they would look at you blankly, and they just wouldn't know what to say. It's labor lawyers who understand it. So where did the term come from? Where do you see the first mention of it? And it's in the Treaty of Versailles. That's where you see it. So looking at the Treaty of Versailles and how it was written, basically in late 1918, at the Ministry of Labor in London, a small group sat and wrote most of what became Part 13. They were in discussions with their French counterparts. And they wrote it, as you know. And by the way, it was the only proposal that was put forward. So that's the only thing that was discussed at the Labor Commission. But in January, just before it was supposed to start, the conference that is, the group said, somebody said, I think we need like a preamble. We need an introduction. And I think you all know it. That talks about certain conditions of labor that require urgent attention because the appalling conditions threaten peace. In that list, you know, the list that says 8-hour day and eliminate child labor. In that list, and this is a quote, it says, recognition of the principle of freedom of association. The principle of freedom of association is mentioned in exactly one other place in Part 13. There's a section called General Principles. Some people still call it the Labor Charter. During the committee's hearings or sessions, the French particularly said, well, it's very nice that we're going to pay attention to this, but what values will this ILO have? And that's where the Article 427 got written. And in it, it says the right of association for all lawful purposes. by the employed as well as the employers. So that's the value that the ILO has from the beginning. But there is no amplification in Part 13 about what this means. And from what I could tell by reading various memoirs and old things written at the time, there was no discussion of this point. It wasn't controversial. There were other controversial things, but not that. By the way, I should tell you that I can't get into this, that the French has a slightly different translation. Once again, freedom of association is a concept that it's like pictures flash in your mind. In French, liberté syndicale looks at it more from the union's viewpoint. What can the union do? But it's like two sides of the same coin, more or less. So, what was the problem the British were thinking about in 1918, 1919? And its combination. Tony, you can talk about this more than I can, but at common law, there was a problem, and the British first put it forward. Like they passed the wide-ranging combination acts and right in 1799 and 1800, where they said workers in all industries were prohibited from combining and basically seeking higher wages. They just were not permitted to do it. That was later repealed. But throughout the 19th century, in British law, there was this problem that if workers combined, the law was hostile to it. And it goes right up to 1901, where they say, oh, workers can combine, but it's when they do something that now the problem arises. Well, of course, they're going to perhaps use economic weapons to exert pressure on the employer. So maybe that's a breach of contract, maybe it's an economic tort, whatever. We won't go into the Taft-Fowle case, but that was the big problem in Britain. They did enact a statute in 1906, but still, there was all issues around this. In the United States, remember our law is based on British common law, the situation was even worse. The first American case in 1806, Philadelphia Cordwainers, my home city, was a very interesting one, because something that was lawful if an individual did it became unlawful if a group did it. So if an individual shoemaker said, I will not make a pair of shoes for you unless you pay me X, that's lawful. But if 10 of them agreed that they would not make shoes unless they were paid X, that became unlawful. In fact, it was a criminal conspiracy originally. So that throughout the 19th century, the situation was similar in the United States, this hostility to combination. In fact, it got worse in the early 20th century with a statute called the Sherman Antitrust Act, which was supposed to be directed at big business, but was used against unions, that they were in restraint of trade. So those were the British and the Americans adverse at the Paris Peace Conference. This was a huge problem for them, and they used the term freedom of association. And it's admired. That's what they were using that term for, that people had a right to join together to seek better conditions of labor. And to do that, it was assumed that they would be engaging in collective bargaining, and they might be using economic weapons, picketing, strikes, and boycotts. By the way, the chair of that committee, the subcommittee, where Britain, France, and the United States were the key players, the chair of it was an American who was the head of the Central Labor Federation and himself had almost gone to jail for organizing a boycott. So it was really in their minds. Let's jump. So we have that in 1919, 1920s. At the ILO, they adopt Convention 11, rights of for workers in agriculture, and say they have rights of association, which the same as industrial workers. So somebody says, well, what sort of rights? And in the 1920s, there are these studies, an important report, the Code report of 1924, thought that they'd have an instrument on this. A middle ground was sought. The major stumbling block was there a right not to join a union? That was the big stumbling block. In 1927, the office proposed a questionnaire that would have probed what were deemed lawful purposes because of Article 427. Interestingly, well, I just have to say, the office already knew that in some countries there were differences about what was allowed. And points of controversy were the closed shop and sympathy strikes, for instance. Both the workers and the employers opposed the questionnaire. They both thought they might lose out by the results. So they opposed it. And as a result, the issue of frequent association was dropped for the time being. But a 5-volume study was published in 1927 on the subject, which actually became very useful 20 years later, because it's clear that the office had a very comprehensive view of the situation in the member states. Well, we know in the 1930s, fascism, Germany dissolves independent unions. I mean, nothing's happening on this front in the 1930s, and of course, during the war. 1944, of course, we have the Declaration of Philadelphia, and what's there? Freedom of association as an essential value. Now, this is where it gets interesting. Sometimes external pressure can produce an opportunity. In June 1945, the United Nations was established. And in January 1946, the Economic and Social Council was established. That ECOSOC was not like today's Economic and Social Council. I'll just say that. It was slightly different. And the mandate of the 1946 ECOSOC, to some extent, seemed to overlap with the ILO's turf, I could use that word. And the relationship between the two bodies was not at all defined, just wasn't. So that there was great concern at the ILO, the tripartite ILO, that somehow the new UN and ECOSOC were taking its work. In early, like January of 1947, the World Federation of Trade Unions asked ECOSOC to consider the guarantees relating to the exercise of trade union rights. Immediately, this referral to ECOSOC, not to the ILO, this was strongly opposed by the American Central Labor Federation, and which they thought the World Federation was communist dominated. Turned out to be true. The American Federation made its own referral to ECOSOC on the same subject because they wanted to frame the issue in their way. They also wanted to say the matter is properly within the competence of the ILO. I'll come back to the AFL's question, way they framed it. So that was January, February. February, March session of ECOSOC. ECOSOC decides to refer the matter to the ILO at the next ILO session. This is March. The next ILO session is the conference in June. And ECOSOC asked for action and a prompt report back in time for the next ECOSOC session, which was July. So I really need to highlight this, the extreme time pressure that was put on the ILO, the conference, to act. They basically had 3 months. Well, the happy outcome, if I could say that, was what had eluded the ILO for 20 years was accomplished in 3 months. What was the key to it? Well, the key was the ILO had done all this work. And so to me, the preparatory paper must have been written as fast as the typist could type. They knew it all, and they got it out super fast. And it reviewed the history of freedom of association, which they knew. And it was blunt in analyzing the reasons for failure in the 1920s to reach agreement. And it was emphasized by the director at that point, Edward Phelan, about what those reasons were. Now, Edward Phelan was the person who drafted most of Part 13. He certainly had been there in 1919. And he's saying, and he'd obviously been at the ILO the whole time, pointing out this is the reason why we failed, because we got into this quagmire. So the preparatory paper put 2 approaches before, I would say the conference, but it put 2 approaches. One approach was, let's have a list of detailed regulations. The other approach was, let's present essential principles and provide a sufficient guarantee for the free functioning of employers and workers' organization. Now that's, of course, what obviously the office preferred the second one for the reasons of speed. If they couldn't do it in 5 years in the 1920s, how were they going to do it in 3 months in 1947. So they really pushed the essential principles approach. There was a special committee on freedom of association and industrial relations, which was chaired by David Morse, who was the United States government representative, and the next year would become Director General. You can read this. What the committee met several times, long reports. And if you, I have an article in the International Labor Review with all the citations where you can look at this. But there was only one serious, really serious disagreement within the committee. And once again, it's whether there would be mention of a right not to join a union. Other points were raised. They'd all been raised in the 1920s, such as how will we treat public employees and civil servants versus public employees, and what role national law has and these were all things that had already been discussed. But happily, the committee on freedom of association supported the idea of the essential principles and putting that as the basis for Convention 87. I would mention in the discussions in 1947 and 1948, neither governments nor employers proposed that there be any limitation on the right to strike. So they're raising issues, but nobody says there's no right to strike, or that it's quite minimal. It's not that the issue wasn't noticed. Remember, we go back to 1947 when the American Federation of Labor went to ECOSOC, it listed issues to be considered, and it specifically listed the right to strike as an issue that should be considered. So I can't go through this because of the amount of time we have, but to say that Convention 87 listed the essential principles. Both sides said there were compromises. The workers felt it didn't go far enough. And the employer's vice chair said, well, there's compromises, but we leave certain matters for the future. Both groups supported the draft that was presented to the conference. And on the point of national law, Léon Jouhaux, who had been there in 1919, he was the workers' vice chair, really criticized this idea of bringing up national law. Especially, can you imagine after fascism? Are you going to say national law is superior to international law? Why do we even have international law? It's ridiculous. It was a very strong, you'd have to read very eloquent comments. So Convention 87 gets approved. Now, let's go to that delicate period. Gets approved in 1948, but there is really no change from the draft in 47. Between 1948 and 51, the political situation generally in Europe and maybe worldwide was very delicate. The World Federation of Trade Unions is still pressing. In fact, at June 1949, he's an observer from the WFTU, says that the position that action under Convention 87 is sufficient is unsatisfactory because the convention does not recognize the right to strike. Well, you can imagine various people are unhappy about that. So during this period, the governing body is grappling with how the ILO can respond quickly to the complaints related to suppression of trade union rights. And they also are aware that the existing machinery could not easily accommodate many complaints for two reasons. Firstly, in 1945, the Constitution had been amended to make freedom of association a principle of the ILO that membership implies that you have accepted it. So there were member states who had the obligation, but they hadn't ratified Convention 87. So they would never be brought before the Committee of Experts. And the second reason was that the speed. The Committee of Experts, the time it would take to get there, it's not very speedy, and it doesn't look at individual complaints usually. So something else had to be devised. Those of you who are terribly interested, there were various proposals. In fact, the one the office favored was not the one accepted. The governing body decided to take hold of it itself, that it would establish its own committee, a committee of the governing body, a tripartite committee to handle these complaints. And you know, it's Papa already mentioned the first year. This was November 1951 when it was approved. And in early 52, that was their first year of operation. They had various cases. I want to say all 9 members on the Committee of Freedom of Association that year had been at the 47 and 48 conferences. It included the employer's vice chair and the worker's vice chair. were on the Committee of Freedom of Association. So they certainly knew what Convention 87 meant. And as Papa mentioned, the case about involving Jamaica is interesting. Jamaica was still a British colony. There was a lot of turmoil there against colonial rule, demonstrations and things. And the colonial government banned all meetings, union meetings included, and that's how the complaint went to the Committee on Freedom of Association. Today, we would say, well, that would have been if it was a strike, we would have said it was a political strike, it's not covered. By the way, that was the outcome. They said that the British government had not infringed on freedom of association. But outright, they said, this is a direct quote, the right to strike and that of organizing union meetings are essential elements of trade union rights. It's 1952. Outright say that. And you have to think that those who were there when Convention 87 was, written and approved. In 1952, they are saying that outright. It seems to me that one has to agree that it is an essential element of trade union rights. So I will stop there.
Thank you very much, Janice, Professor Bellace, for this very insightful presentation. And without further ado, I would like to now pass the floor to Professor Tonia Novitz. Professor Novitz is a professor of labor law at the University of Bristol in the United Kingdom. She's a graduate of the University of Canterbury in New Zealand and at the University of Oxford. She's held fellowships at leading international institutions, including the ILO in Geneva and the European University Institute in Florence. Professor Novitz, among the many things that she has done, is the author of a landmark 2003 monograph that still remains a reference in the field around the protection of the right to strike at the international and European level. And very recently, she co-edited with other colleagues open access special issue of the Comparative Labor Law and Policy Journal on the right to strike, which we were extremely pleased to host on the journal. Professor Novitz, you have the floor. Thank you very much.
Thank you so much, Valerio, and the Nathanson Centre for inviting me to speak on this panel. It has been a great pleasure to work with Papa and his team at the ITUC as they prepared their written and oral statements for the International Court of Justice. And many of us were doing this on a pro bono basis. The question might be why? Well, we did so because the case is so very important. I think it's emblematic of national, transnational, and international determination on the side of workers to protect the right to strike. If we cannot look to the International Labour Organization, the ILO, and ILO Convention 87, which has been regarded as a key source of this entitlement for so long, where should we look? Indeed, this case is also about recognizing and preserving the influence of the ILO and its supervisory bodies in the world of work. As Harold Coe said in his closing submissions for the ITUC at the International Court of Justice, however the court rules, workers will still strike. Even without international legal recognition of the right to strike, strikes as a phenomenon of employment relations will still continue, but their organizers and their participants may not be protected under international or domestic law, and that will have consequences regarding justice at work globally. At a time when labour markets are not confined within national borders, when the expanding operation of multinational corporations and global supply chains have challenged domestic labour standards and undermined local collective bargaining, we need international ILO standards more than ever. Those in the world of work should be able to rely on a right to strike, which has been recognised, as the other speakers have said, for decades at the ILO, and with good reason. I'd also agree with the submission of Vanuatu before the ICJ that the right to strike is essential to workers' organisations' participation in a just transition for sustainability in the context of the current climate change crisis. But I thought my contribution to these discussions today could be to outline the legal arguments presented to the International Court of Justice, the ICJ, and their wider relevance to ongoing protection of the right to strike. So I am going to try. Oh, I need to wait for the permission to bring up the slide in question. There we go. Now I can do it.
Sonia, I think I'm
Thank you,
sharing the-
Valerie.
Yes.
Yeah. Are you happy to just bring up this one slide? Consent.
You have to consent.
There we go. And if we can just bring it to play from the start. Is it possible to bring up the slideshow? Thank you, that's wonderful. So the employer's argument, as has been explained to you, is that because the precise words right to strike were not inserted into the text of ILO Convention 87, the right to strike is not protected under the instrument. The response, the legal arguments presented by the ITUC to the ICJ centred on questions of treaty interpretation under Articles 31 and 32 of the Vienna Convention on the Law of Treaties of 1969. This is not new ground. There is a book that I want to recommend to you titled The Right to Strike in International Law, which began as a collectively drafted legal opinion in 2012 in response to the employer's walkout of the CAS, and was published by Hart Publishing 5 years ago in 2020. This was produced by a team of authors, but Jeffrey Vogt at the Solidarity Centre and ILO was the lead author. And that book, referred to in the ITUC submissions, deserves particular credit for identifying these key arguments and signalling their importance. Still, it might be helpful here to both outline and reflect on these arguments in terms of their contribution to the litigation and their broader significance. Article 31(1), as it says here, requires that Convention 87 be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms in their context and in the light of its object and purpose. So context means the text, preamble, and annexes, as well as any agreement relating to the conclusion of the instrument. Let's begin with ordinary meaning, which both Papa and Janice have mentioned. What are the terms that we're interpreting? Article 3(1) of Convention 87 provides that workers and employers' organisations shall have the right to organise their administration and activities and to formulate their programmes. Article 3(2) says that public authorities shall refrain from any interference which would restrict this right or impede its lawful exercise. And Article 10 further explains that the term organisation for workers means any organisation of workers for furthering and defending the interests of workers. It is, on a literal meaning, hard to see why the right to strike should somehow be excluded from the activities of workers' organisations, or why the right to strike should not be part of the programme of activities aimed at furthering and defending workers' interests. There is considerable danger globally if reference to freedom of association and the right to organise is defined in such narrow terms that workers' activities cannot include strikes. After all, as we all know, without the potential for access to the penalty of collective action, such as the right to strike, there would be little leverage to bring employers to the bargaining table. And as the saying goes, it's been mentioned already, without the right to strike, collective bargaining could be reduced to collective begging. And this is precisely why the employers group at the ILO, through the International Organization of Employers, the IOE, is making this argument. to reduce workers' capacity for effective collective representation and bargaining. If the broad-term activities were not to include the right to strike, we might expect this to be expressly excluded from Convention 87. But that hasn't happened. And there are, after all, certain express limitations on workers' and employers' collective activities in the Convention. For example, such activities must respect the law of the land under Article 8.1, although the law of the land shall not be such as to impair the guarantees provided for in the Convention under Article 8.2. Also, police and armed forces are expressly excluded from Article 3 entitlements under Article 9. However, there is no specific exclusion of strike action from workers' legitimate activities. In other words, it seems pretty clear that the ordinary meaning of activities prevails. Put simply, the ordinary meaning of Convention 87 cannot be squared with the claims of the employers' group. There is also an analogy to be drawn with a much earlier case decided by the ICJ's predecessor, the Permanent Court of International Justice. The PCIJ held in an advisory opinion back in 1922 on the competence of the ILO in regard to international regulation of the conditions of persons employed in agriculture, that even though the word agriculture was not explicitly mentioned in the first ILO constitution, Part 13 of the Treaty of Versailles, which Janice just mentioned, this was a matter which came within the sphere of ILO competence under that treaty. Given the general wording of the relevant provisions of Part 13, that inclusion was regarded by the court as obvious. There was no real ambiguity. And there's no real ambiguity here in relation to Convention 87 either, regarding the right to strike. Article 31 also requires reference to the object and purpose of the international instrument. The preamble to Convention 87 refers in turn to the preamble to the Constitution of the ILO, and that preamble declares recognition of the principle of freedom of association to be a means of improving conditions of labour and of establishing peace. Once again, it's very hard to see how conditions of labour can be improved without any potential recourse to strike action. Employers then would have little incentive to bargain. Indeed, good faith means giving effectiveness to Convention 87 and being aware of the dangers in terms of workers' ability to collectively bargain, to even begin to bring an employer to the bargaining table if a strike is not a protected activity. That reality is reflected in the other factors that are to be taken into account under Article 31, Paragraph 3 of the Vienna Convention on the Law of Treaties. One is, under Article 31.3a, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. And here, as Phoebe Okawa very eloquently said before the International Court of Justice, we might think of the compromise agreement concluded at the ILO on the 23rd of February 2015, precisely on this dispute over the legal status of the right to strike. That agreement took the form of a joint statement of workers and employers groups. This joint statement recognized the mandate of the Committee of Experts as defined in the committee's own report of that year, while also acknowledging, and here I'm quoting, the right to take industrial action by workers and employers in support of their legitimate industrial interests is recognized by the constituents of the International Labour Organization. More important, perhaps, is the agreement reflected in the government group statement concluded at the same time, which says the right to strike is linked to freedom of association, which is a fundamental principle and right at work of the ILO, and in particular, the government group recognized the value of the ILO's supervisory system and why it is special, particular, and important. Also recognized under Article 31.3b is other state practice. At the ILO and elsewhere, there's extensive state practice in support of a right to strike. At the ILO, that's evident in the content of related instruments and also in the participation in supervisory bodies. So, for example, the ILO Voluntary Conciliation and Arbitration Recommendation number 92, adopted by the International Labour Conference in 1951, explicitly states that no provision of this recommendation may be interpreted as limiting in any way whatsoever the right to strike. Article 1 of ILO Convention No. 105, the Abolition of Forced Labour Convention of 1957, provides that states parties are not to suppress and not to make use of any form of forced or compulsory labour, and cites in particular as a punishment for having participated in strikes. It's evident that these ILO instruments were framed in these ways on the assumption that the right to strike arose by virtue of freedom of association protected by the ILO Constitution and by Convention No. 87. Another aspect of state practice is government participation in the tripartite Governing Body Committee on Freedom of Association, the CFA, and state cooperation with ILO commissions of inquiry and fact-finding and conciliation commissions on freedom of association. Indeed, the Tripartite Committee on Freedom of Association has, through consensus involving government, worker, and employer representatives, agreed on the labour standards expected of states that can be derived from the constitutional principle of freedom of association. And these, in turn, have guided the CFA and the Committee of Experts when assessing compliance with Convention 87. Protection of the right to strike was not somehow invented, as the IOE has suggested, by a group of experts detached from the realities of employment relations, but over decades and through tripartite agreement. With full employer, and more importantly, in the context of the Vienna Convention, full state participation. And this brings us to any relevant rules of international law as prompted by Article 31(3)(c) of the Vienna Convention. Here we have a wealth of examples in terms of human rights instruments under which the right to strike has been protected. What is notable is the common understanding by human rights supervisory bodies that the guarantee of freedom of association encompasses protection of the right to strike. Examples include the Human Rights Committee in its interpretation of Article 22 of the International Covenant on Civil and Political Rights, the European Court of Human Rights in its application of Article 11 of the European Convention on Human Rights in cases like Ognevenko in Russia, and even more emphatically, the Inter-American Court on Human Rights in relation to Article 16 of the American Convention on Human Rights. It's alarming that the thoughtfully established jurisprudence of these bodies would seem to be challenged if the ICJ does not accept, as all these other international human rights supervisory bodies have done, that the right to strike follows from protection of freedom of association and can be derived by Convention 87. That is precisely what the European Court of Human Rights says in the case of Ognevenko. One has to be hopeful that the World Court will not allow this to happen, that it would have suitable deference both to ILO supervisory institutions and these other UN human rights mechanisms. What remains regardless is the express recognition of the right to strike in provisions such as Article 8 of the Covenant on Economic, Social and Cultural Rights, Article 6 of the European Social Charter, and Article 8 of the San Salvador Protocol. At least the right to strike cannot be completely lost, while these human rights instruments concerned specifically with socioeconomic rights remain. But it would be very odd and problematic if that right were not recognized any longer as protected at the ILO under Convention 87, which is much more accessible for many states, and where, for example, workers' organizations in certain African countries tend to bring their concerns and complaints. Finally, as it's been said, if there is ambiguity as to the meaning of Convention 87 and its treatment of the right to strike, then we could look under Article 32 at the travaux préparatoires, the preparatory materials relating to the drafting of Convention 87. They then become relevant, but only if the meaning is otherwise unclear. I think it's very hard to view the meaning of the text of Convention 87 as unclear, but if we did have to, then we could look at these preparatory materials. What is evident, and for the reasons that Janice explained, is that the chairman of the drafting committee made clear to the participants that Convention 87 was not going to be a very detailed code of regulations. It was not going to specify all facets of freedom of association, such as precise mechanisms for collective bargaining or exercise of the right to strike. Instead, the chairman recognized that Convention 87 was a concise statement of fundamental principles. And there's evidence that those engaged in the drafting process did assume that this entailed protection of the right to strike. This was a drafting choice and not an intention to exclude the right to strike, as Mexico said in its submissions to the International Court of Justice. For example, the Indian delegation sought an exception for the armed forces and police because they were not authorized to take part in collective negotiations and had not the right to strike in India. Now, this proposal from the Indian delegation was adopted and incorporated in what is now Article 9 of ILO Convention 87, at least in part in response to the expectations of the scope of Convention 87's protection of the right to strike. That general statement in Convention 87 of the rights of workers to pursue their activities, to defend their interests, enabled the application of its terms to then be placed in contemporary circumstances. In other words, to promote a workable protection of the right to strike at the ILO with the assistance of the ILO supervisory bodies. Today, that threat to this right seems indefensible. It is these essential legal arguments which were put by the ITUC Council to the World Court. I've obviously abbreviated those submissions here, but it has been my pleasure to explain their broader contours to you today. And I do hope it's been helpful, and I'm very happy to answer questions later. Thank you.
Thank you very much, Tonia, for this presentation. And I'm sure there will be questions for you afterwards about it. Now let me move to the next speaker. The next speaker is Stephen Barrett. And Stephen is a leading Canadian labor lawyer and the managing partner at Global Partners in Toronto. He's also an alumnus of Osgoode Law School, of which we are, of course, very proud. And Stephen has appeared before the Supreme Court of Canada in many of the country's most significant labor and constitutional cases, helping to shape effectively the modern framework of collective bargaining and workers' rights in Canada. Now, Stephen has once been described as the Wayne Gretzky of labor law, which for you, those of you that don't know hockey as I don't know hockey, is the same as saying the Lionel Messi or the Michael Jordan of labor law. So for his unmatched impact on the practice and field of labor law in the country. If I understand correctly, Stephen is going to discuss the significance of recognizing the right to strike at the international level and how the ILO jurisprudence has shaped effectively Canada constitutional law. So Stephen, thank you very much for being with us today, and you have the floor.
Thanks, Valerio. That's Wayne Gretzky when he played hockey. He's taken a bit of a turn to the right, so it's just Wayne Gretzky, the hockey player, not Wayne Gretzky, the retired politician. I thought about titling my presentation, for those of you who know the TV show South Park, Blame Canada. And why that title? Because to some extent, events in Canada are at least partly responsible for the political and legal dispute over whether Convention 87 protects the right to strike, the role of ILO supervisory bodies, and the referral of this question to the ICJ. Now, you've heard that over time there have been tensions and employer concerns over the extent to which Convention 87 protects the right to strike, but it really wasn't until 2012 that this became a real crisis and deadlock. And who was leading the employer charge in 2012 at the Committee on the Application of Standards? Sonia Regenbogen, who's a Canadian employer side labor lawyer representing Canadian employers at the ILO, and in 2012, the employer spokesperson and I believe vice chair at that committee. Now, why would a Canadian be playing such a prominent role in seeking to overturn long-standing recognition of the right to strike under Convention 87? To understand that, we need to do a brief tour of the evolving treatment of the right to collective bargaining and the right to strike under Canada's Charter of Rights and Freedoms and the protection of freedom of association. Initially, in 1987, when the charter was relatively new, our charter came into effect in 1982, and despite a strong dissent from then Chief Justice Brian Dixon, the Supreme Court of Canada held that freedom of association protected only the right to join unions, to form unions, but not to do that which unions are formed for, i.e. to organize, collectively bargain, and strike. According to the majority, and some of these arguments will be familiar to those of you who follow the ICJ proceedings and what you've heard already today. The right to bargain and strike were merely modern rights created under the Wagner Act, the North American Wagner Act model. It was important that the legislature be able to balance competing employer and union interest, and the courts not be involved in that. The court also, was concerned about extending protection under freedom of association to the activities or objects of an association, and no matter how essential they might be. Often the example of a gun club. It's essential to a gun club to have the right to bear arms, as if that's analogous to trade unions and collective bargaining. Moreover, freedom of association didn't have any explicit protection for the right to strike or the right to bargain, and it shouldn't be read in. In his dissent, Chief Justice Dixon, who found that the right to strike should be protected, in large measure based his view on the extent to which international human rights obligations recognized and protected the right to bargain and the right to strike as part of freedom of association. And what was the most relevant and important international instrument to which Canada was bound? You guessed it, ILO Convention No. 87, which Canada has ratified and which the Chief Justice in his dissent spent considerable time reviewing, and which he recognized based specifically on the views of the Committee of Experts and decisions of the Freedom of Association Committee protected both the right to bargain and the right to strike. And so until 2007, however, that remained simply a dissenting view in the Supreme Court of Canada. But in 2007, in the Health Services decision, the Supreme Court of Canada reversed the Alberta reference, the 1987 Alberta reference of 20 years earlier, and held that the reasons for denying constitutional protection to collective bargaining as part of the freedom of association guarantee could not withstand principled scrutiny. And while the court explicitly went out of its way to say they weren't finding that the right to strike was protected, as if somehow you can have collective bargaining without the right to strike, in finding constitutional protection for collective bargaining, the majority relied heavily on the same ILO Convention No. 87 and the same Freedom of Association Committee and Committee of Expert views as had been a cornerstone of the original dissent in 1987. So to return to Ms. Regenbogen and the role of Canada, she and Canadian employers she represented had, until the Supreme Court of Canada used ILO Convention No. 87 to inform protection of bargaining under the Canadian Charter, they've been content to accept or at least not contest ILO Convention 87 protection for the right to strike. Because the worst that could happen was that there be, as there were, complaints against Canadian governments and legislatures interfering with collective bargaining. The ILO Freedom of Association Committee would find that there had been a breach of the ILO conventions, but almost invariably this was ignored by the various Canadian governments who interfered with collective bargaining. But once the Supreme Court of Canada began to rely on ILO protections in a meaningful way to inform constitutional protection for the right to bargain in Canada, what followed was a concerted effort at the ILO, led by Canada, because they had the role as employer lead on the Committee on Application of Standards, where, as you've heard, this dispute arose. A concerted effort to weaken ILO protections, which emerged precisely when it mattered in the domestic law of Canada in terms of the scope of the freedom of association protection. And of course, it wasn't only Canadian employers who understood that the stakes were raised. This was true more generally because, as you've heard, of decisions of various other courts, including the European Court of Human Rights, who had also looked to ILO conventions, including Convention No. 87, to ground protection for the right to bargain and the right to strike. So while Canada took the lead, it was doing so on behalf of the global employer communities. And so what followed was a concerted effort to obstruct and overturn ILO Convention 87 protection for the right to strike. It had suddenly become clear to Employer Council in Canada and elsewhere around the world that it was important to contest ILO protection and to attempt to cast doubt on the legitimacy of the supervisory bodies that had consistently, since 1952, we've heard, recognized protection for the right to bargain and the right to strike, in an attempt to preclude domestic or regional or international courts from relying on that protection to ground protection under their relevant instruments. And that strategy was well underway when the Supreme Court of Canada finally came to consider in 2015 whether it should reverse the 1987 Alberta reference decision and finally find freedom of association protection not only for the right to bargain, but also for the right to strike. Now, the main organization representing Canadian employers, the Canadian Employers Council, intervened in that case, and their argument was precisely focused on Convention No. 87. And they argued, as has been argued since 2012 and as they argued before the ICJ, that there was no tripartite consensus at the ILO, that the right to strike was protected, that it was clear from the preparatory materials that it wasn't intended to protect the right to strike, and you've heard Tanya about that, that the Committee of Experts and the Freedom of Association Committee had no official or lawfully constituted interpretive authority, and that only the International Court of Justice could interpret Convention 87. And they also made an argument that I think is replicated in some of the arguments being made before the ICJ, that if the right to strike, if ILO Convention 87 had application in Canada, whether directly or through the freedom of association guarantee in our Constitution, then much of Canadian labor law would be offside of ILO conventions because we ban recognition strikes, we have exclusive bargaining agency, we don't allow sympathy strikes, and so on. Now, for our part, and we represented the Canadian Labour Congress, as Valerio noted, we said that the decisions of the Committee of Experts, or the views of the Committee of Experts, decisions of the Freedom of Association Committee were sufficiently authoritative within the ILO supervisory structure. We relied on the views of various international labor law scholars, some of whom are here: Janice Balache, Tanya Novitz, Alan Bogg, Keith Ewing, Bob Hebden, and so forth. In fact, tell a little story. The government of Saskatchewan had relied on a statement in Tanya's 2003 paper or work on the right to strike at international law, in which she said that there was no explicit protection for the right to strike under these ILO conventions. And so I remember trying to find Tanya, who I didn't know at the time, and finding her, chasing her down, I think, on vacation. And she faxed me excerpts from the 2003 treatise, which made very clear that despite there being no explicit reference, it was uniformly understood that the right to strike was protected. And so what did the Supreme Court of Canada decide in the SFL case? Well, they doubled down on what Chief Justice Dickson had said 30 years earlier. To quote them, they said, at the time of the Alberta reference, Dickson's reliance on Canada's international law commitments did not attract sufficient collegial support to lift his views out of their dissenting status, but his approach has more recently proven to be a magnetic guide. And they went on to review ILO Convention 87, rely on its protection of the right to strike to inform the scope of our protection of freedom of association. And they didn't only rely on international law, the court also recognized, as has been argued before the ICJ, that if the right to strike was not protected, collective bargaining would be, to quote the court, inconsequential, a dead letter. Elsewhere, the court described the right to strike as the irreducible minimum of the freedom to associate and as the powerhouse of collective bargaining. In fact, quoting Otto Kahn-Freund and Bob Heppel, the court emphasized that a legal system that suppresses the freedom to strike puts workers at the mercy of their employers. Well, as I noted at the outset of this remark, I was tempted to title my presentation Blame Canada. On reflection, I think Canada has also taken at least some limited, or should be given some limited credit for recognizing the importance of ILO Convention 87 and its protection for the right to strike. In fact, I was reviewing the transcript of the submissions before the ICJ, and it was gratifying to hear the submissions of Professor Okawa before the ICJ on behalf of the ITUC, relying on the Supreme Court of Canada's recognition in the SFL case that suppression of the right to strike in and of itself amounts to substantial interference with collective bargaining. And actually to read Canada's written submissions, which I just found this morning, where even the government of Canada, as did so many other governments, accepted ILO protection for the right to strike under Convention 87. Allow me to conclude with just a few remarks about why the ICJ decision is so important. Indeed, as was emphasized throughout the submissions made to the ICJ, at a global level, at a country-to-country level, at a workplace-to-workplace level, ILO protection for the right to strike fundamentally matters. It matters to the legitimacy of collective worker action and power. It matters at the cultural level. It matters at the level of politics, the level of advocacy, the level of policy and standard setting, and of course, at the legal and constitutional level. And as the Somalian submissions to the ILO put it, the ICJ decision will also determine the stability and credibility of the ILO's supervisory system that has guided states for decades in applying international labor standards. But I can speak best to Canada and to the specific impact and importance of ILO Convention 87 protection for the right to strike here. First, in my view, there's no doubt that one of the reasons that the judges of the Supreme Court of Canada were ultimately persuaded to reverse course from their initial 1987, from the black hole into which they had shoved constitutional protection for the right to bargain and the right to strike. One of the key reasons is that they recognized how out of step that decision was with the long-standing and emerging international consensus anchored most firmly in ILO conventions and principles that freedom of association was meaningless without protecting collective bargaining, and this in turn required protection of the right to strike. Secondly, it still matters very much here in Canada, even here in Canada. The composition of our Supreme Court has changed. it's fair to say that when it comes to labor law and worker rights, it is a less progressive court than it was even a decade ago. There are fewer members on the court who are steeped deeply in understanding the importance of collective bargaining and the right to strike. And there are some indications that the court may not be as committed to looking to international law and open to alternative interpretations and applications of international law. And there are many academics and newspaper columnists and practitioners on the right who continue to challenge the legitimacy of the court's freedom of association decisions. And so if ILO Convention 87 were somehow found not to protect the right to strike, this would be very unhelpful in its impact even here in Canada. And of course, there are also broader social and political and economic currents and shifts in play all around us, especially living in Canada, given what is happening to and emanating from our much larger neighbor to the south. In this context, ILO protection and recognition of the right to strike, and in particular, it's being embedded in ILO Convention 87 really matters. It makes it harder for the court to retreat, and if it were to disappear, it could have profound consequences for Canadian constitutional protection for the right to strike. And while I am not one to romanticize the relative importance of legal protections compared to actual on-the-ground worker power and organizing and mobilizing, law and this protection does provide important space for that power to be exercised. And it makes governments think twice before seeking to repress it. So despite that, governments here in Ontario, in the province of Ontario, where I am, and the federal government have moved to override the right to bargain and to strike, even after charter protection was recognized. And Canadian workers have twice in the last 3 years defied back to work directions and legislation purporting to terminate their lawful strike activity. In 2022, it was education workers in Ontario seeking wages that would try to move them somewhat out of poverty subsistence. And most recently, this past August, it was flight attendants at Air Canada fighting to overcome unpaid work at Air Canada, who the federal government had ordered back to work. And in both cases, these workers defied these legislative and ministerial directions to terminate their strike. And in both cases, these workers secured important collective bargaining gains. Now, I was involved with other members of my firm in acting for those workers. And I can tell you that in both cases on the ground, it mattered to those workers and it mattered to the public support they garnered when they defied and continued to strike in the face of legislation and directions purporting to terminate the strike. It mattered to them and to the public that they were exercising what the Supreme Court of Canada has held to be their constitutional rights and freedoms. And so I hope you would all agree with me that ILO Convention has played and will hopefully continue to play a very important role in protecting the right to strike in Canada and globally. If we were all together in person, I would ask you to raise a glass in the hope and expectation that the ICJ decision will confirm that, and Papa, that the rug will be put securely back under your feet. Thank you.
Thank you very much, Stephen, for this great presentation. And now let me turn to the last speaker of this panel, and the speaker who will conclude our presentation for today is Professor Silvana Sciarra. Professor Sciarra is the former president of the Italian Constitutional Court. She is the first woman who was elected to the court by parliament and its second female president in Italian history. She's a graduate of the University of Bari and held academic appointments at the University of Siena and European University Institute in Florence. She's now a professor emerita of labor law and European social law at the University of Florence, a member of the senior editors board of the Comparative Labor Law and Policy Journal, and one of Europe's foremost scholars in comparative and European labor law. She also has advised the European Commission on numerous projects about worker rights in general, and she also holds honorary doctorates from the University of Stockholm and the University of Oslo. Silvana, thank you so much for being with us today. You have the floor.
Thank you, Valerio, and also thank you for your patience when I was struggling through the connection, which I managed to do from my phone, so I hope you can hear me properly. Well, it's been wonderful to listen to the speakers today. Let me just point to the importance of being together again in this meeting, and thank you, Valerio, for organizing it, because it's as if we find again after many years a strong identity of the community of labor lawyers throughout the world around a theme which is so identitarian for the labor law itself. I found Janice's history from inside with such an incredible amount of details and indications on how things went over the years, very, very useful and very thought-provoking. And it's true what she says, that very often things happen because there is pressure from outside. There is something happening. And this is what I think is happening nowadays, and why we all feel under pressure waiting for the International Court of Justice to deliver its judgment. And as for Tonia, she again reminds me of this idea of, how can I say, passionate labor lawyers throughout the world who get together and help pro bono. She mentioned some of them, to deliver the opinions, to help those who chose very, I think very rightly so, to act before the court, and so to open a new adventure, a new procedural, and not only procedural adventure, because contents are so relevant on this issue. I have to say that the ILO conventions have been incredibly relevant in Italy in the late 1940s and early 50s, because the Italian constitution is started to be was enacted in 1948, and the progressive labor lawyers, those who actually wrote Italian collective labor law, luckily my mentor was one of them, Gino Giugni, back in those years, they heavily relied on the ILO conventions, which were not so well known and so well received by the community of scholars beforehand. So it's interesting to see how they continue to be dominant and interesting and incredibly important sources for labor lawyers nowadays. Then I was very interested in listening to Stephen Barrett's presentation, because, of course, we have all been looking in Italy to the Canadian Supreme Court decision as a leading case, and as a case which could, in a sense, strengthen also Italian doctrinal reflections on the constitutional protection of freedom of association and collective bargaining. And I'm also happy because you mentioned Bob Apple and Cam Freund, a couple of the founding fathers of European labor law, because definitely we owe them this never, so to say, ending importance of the definition of collective labor law as part of labor law, which is so much grounded on power relationships. Collective bargaining is based on different balance of powers, hence the importance of the right to strike to rebalance the weaker party's position. I think I may try to add a little bit to this wonderful series of presentations, quoting a couple of examples which came back to my mind when I was thinking of being with you. And again, thank you very much for having me on this webinar. I was thinking of a couple of examples. Back in some years ago, when I was working on Laval, as many of us did, and I was actually asked to write a piece on Laval, which I did jointly with the younger colleagues called Lorenzo Cecchetti for a book on the leading cases, the European Court of Justice's landmark cases. Well, I went back to the notion of exemplary case, which was a case issued, actually a decision issued by the Swedish Labour Court in 2009, when, if my information was correct at the time and is correct now, it was one of the very first times, if not the first time, that punitive damages were issued against trade unions. And why? They needed an exemplary penalty in the aftermath of this highly controversial case, which was Laval. And let me recall another recent case in Italy, which apparently doesn't have anything to do with the first case I mentioned. And this has to do with the recent judgment opinion, rather, issued by the Authority for the Enforcement of the Right to Strike in Essential Services in Italy. It's an authority, not a judge. Because, as you probably read in newspapers, there was in Italy, as in other places in the world, a general strike on October 3rd to support the protest for Gaza and the global Sumud flotilla. Well, the authority declared this strike illegal because there had been no, they had not been observant of the duty to give a forewarning before the actual practice of the actual strike taking place. So a very formalistic decision, in my view, not very well argued, and I say this with great respect for the authority. And leaving aside the technicality, I think this is also an exemplary decision. Exemplary meaning not necessarily a good decision, but exemplary in the context of other decisions, because it shows the total absence, which is something that strikes me, and I think this was also coming out of some of the comments I heard today, the total absence of a contextualized reasoning about the right to strike. In other words, a decision taken, very formalistic decision taken, ignoring the social and political context in which the right to strike was exercised. I need to mention, for those of you who maybe don't remember this, that Italy is one of the very few countries in comparative terms having had a very important decision of the Court of Justice, of the Constitutional Court back in the 70s, arguing for the legitimacy of political strikes when they are not subversive. In other words, when they do not coincide with an action meaning to subvert the constitutional order of the country. And I remember that Lord Wedderburn, another scholar that we ought to recall when we discuss the issues of collective labor law, was very envious of this Italian decision. He thought it was a very good decision and that should be disseminated around the world because it sort of set a stronger emphasis on the right to strike, even when it has a political connotation. So I think this is a lesson to be learned today. And I agree with what I heard from my colleagues before. We always need to contextualize the right to strike within the framework of very important international sources and the evolving nature and evolving contents of international sources. And this is what, in my view, constitutional and Supreme Courts ought to be doing all the time. They ought to be looking at international sources, taking into account in their own rulings the emancipation, the constant evolution of such international sources, and contextualizing them again in the social context we live in, and then political context we live in. So Laval, in a sense, was a breaking point for the community of labor lawyers around Europe, but not only, and it sort of pushed towards legislative initiatives which tried, people may not agree on this, not everybody agrees on the innovative and positive balance that for example, new directive on posted workers introduced. But nevertheless, there was an effort to answer back to an infamous decision, to a decision which was at least controversial. Now, I talked in those years of a snowball effect of the Laval decision. And I think this perhaps can be recalled, this metaphor of the snowball effect, can be recalled for the confrontation between the two European courts that took place more or less after, or more or less in the same years after the Laval judgments were in years, few years later, the same historical breakdown. And I think that the European courts, the Court of Justice and the European Court of Human Rights, had a way of talking to each other, which was rather new, in my perspective, for those years. And that had an impact in subsequent decisions of national constitutional courts. And let me talk of my own experience, my privileged experience within the Italian Constitutional Court. Because I was given a case as rapporteur and then as a drafter having to do with the blockage of collective bargaining in the public sector for many, many years due to austerity measures. And we know the history of many courts acting as important interpreters of the austerity measures throughout Europe. The Italian Constitutional Court was faced with this challenging decision because the blockage of collective bargaining caused the blockage of salaries, of course. Salaries could not be increased during those years. And the court argued for the inconstitutionality of these measures on the ground of Article 39, paragraph 1 of the Italian Constitution, which is the one for protecting freedom of association. Hence, there was a way of linking together freedom of association with the right to collective bargaining, and having stopped collective bargaining, having blocked over the years, therefore for a long period of time, collective bargaining, there was an infringement of freedom of association. It was not easy to convince my colleagues, if I may say something from inside the Collegium of Constitutional Judges, that there was such a link. But then they all agreed on this link, on this connection, on this functional connection, freedom of association, collective bargaining. And what helped me very much in that case, and I'm grateful for having been given the honor to draft that case, that I was inspired by I, together with my colleagues, was inspired by international sources, trying to show that they would provide coherence to a national constitutional court's arguments. So we quoted ILO Convention 87 and 98, and then we also quoted Convention 151/78 because that had to deal specifically with the public sector. And then we quoted Demir and Baikara, the European Court of Human Rights decision, and then many other international sources. which I don't need to quote to such a distinguished audience today. But why did we do that? Because we wanted to show how important it is for a constitutional court bringing together all possible standards, of course, in a coherent way, all possible standards which could make even stronger and enforce and, in a sense, enlighten the national constitutional principle. And this is what happened, because then we referred to the notion of solidarity in Article 2 of the Italian Constitution. So to say, the combined effect, some colleagues in Italy say the optimization of standards. So the combined effect of national constitutional values and rights and international standards, broadly speaking. There was another time that I had an opportunity to quote ILO conventions, although with some problems, because this was a case on dismissals. And there again, constitutional rights had been violated, and there were international sources to be quoted, but the the ILO Convention on Dismissals had not been ratified by Italy. So there was an interesting discussion on, and the judgments actually mentioned this, on the vocazione internazionale, which means that the ILO Convention, even though not ratified by Italy, so to say, accompanies the constitutional principles, even though it has not been ratified. That source encompasses constitutional values. So it is vocationally close to national constitutional values. And it was interesting again to discuss the Vienna Convention on that occasion, because here we know that there is a duty for members of states who have ratified the convention not to act in such a way that the convention itself should be put in danger, be threatened. But on the other hand, you cannot go as far as saying that member states are impeded from not ratifying. So there is also discretion on the side of member states not to ratify the convention. Therefore, the evaluation of that convention comes into the spectrum of analysis of constitutional courts very often. I think it may be crucial in deciding the case before the International Court of Human Rights, International Court of Justice. Let me also mention that I went back in preparation for this meeting to Humpert versus Germany, the case decided by the Court of Human Rights, and the prohibition to strike for civil servants in Germany. And again, here it is important to read the dissenting opinion attached to that judgment, because in that dissenting opinion, we go back to what I was trying to explain before, namely the how ILO conventions must be regarded as part of international law, of the body of international law, and therefore there is a duty to interpret them. There is an obligation to interpret them in the evolution that international law, luckily from my point of view, undergoes. Now, in that case, the Court of Human Rights wanted to avoid a conflict with the National Constitutional Court. Perhaps it wasn't the same case with the Russian Constitutional Court, whereby the court said valid and convincing reasons were needed to grant the violation of the right to strike. So there is a history now of national constitutional courts, so to say, confronting their own rulings with international sources, including the ILO conventions, which were not so often quoted, at least in the Italian tradition, even in constitutional court cases. This is why I think we have an important step to be taken now, whatever happens in the courts in the following days. And I hope, of course, I hope, like my colleagues, I think we go for the best solution. We can raise the glasses, a Canadian colleague was suggesting before, altogether. But I think there is a duty now to continue to act critically as a community of labor lawyers. And this seminar, this webinar, is inspiring for this reason, because whatever happens, we ought to continue to develop critical thinking around this issue, which is very important in the special times we are now living in, the political situation, the rule of law and democracy being threatened in Europe, and the right to strike being so crucial, even in affirming fundamental freedoms which were taken for granted under the Italian constitutional law system. No freedom is taken for granted ever, and I think all freedoms we ought to continue to act and defend fundamental freedoms, both at the national level and the international level. So my thoughts are thoughts of great gratitude for having been in this webinar today, and I want to listen to the questions now and to further comments, because I feel very much inspired by my colleagues' work, and I will continue to listen with great enthusiasm. Thank you, Valerio.
Thank you. Thanks to you, Silvana. Thanks, Professor Shara. Again, this has been a wonderful panel, and we have a high number of questions, and I will select some of those and I will pose those to our panelists. And I think the first question that was raised, and I would like to pose to both Papa and Tonia. Well, first, Papa, there's a question for you. Do you know when the ICJ case will be issued by the court? Can you tell us something about that? But then the question for you and Tonia is, being Convention 87 applicable to both workers and employers, and means strikes activities of workers, why lockouts are not recognized as activities of employers under Convention 87? So I will say 3 minutes each for answering these questions, but you have the floor, Papa.
Yeah, thank you very much, Valeria. It was also really interesting listening to all of you. First, on the question of when, we hope to hear from the court. We don't know, but we work on the assumption that it will be sometime in the spring. So we don't know. Secondly, on the question of the tools for the defense of the tools of freedom of association for both employers and workers under Article 10 in defense of their interests. Before I answer that question, let me say that, yes, a little correction for Stephen. Sonia was in 2013. So my colleagues helped me with some, because I was wondering whether she was there when the case happened, but it's 2013. And as I said, in my comments, I have great respect for my employer counterparts, and Sonia is one of them. We fight a lot, as you can imagine, right? Because we disagree quite a lot on interest and negotiations and so on. But generally speaking, for all my colleagues, my counterparts on the employer side, I have great respect for them. On the specific question, as I said, we feel as the ones who the rag has been, removed, and whose feet the rag has been removed. And I will not be talking about the jurisprudence of the of lockouts for employers. I'm not going to do that, because the question before the court is not that. But sufficient to say that in 1989, in the case on Japan under Convention 87, and I will quote fully what the employer representative said, And this is something that was quoted also a couple of times in the hearing. And I'm quoting, "Far from challenging the right to strike and of lockout, the employers merely wanted the exercise of that right submitted to reasonable restrictions. No member state could accept the restrictions proposed by the committee of experts, etc., etc." This is what they have claimed. I will leave it there. The question before the court is about the right to strike, and I am not going to discuss the jurisprudence on lockouts. Thank you.
Valerio, on that very question, there's a great passage from the SFL decision from Justice Abella that I just, with your permission, just quickly read.
Of course.
The same point, she's responding to that same argument that there should be a symmetry between the employer right to lockout and employee right to strike. And what she says is, in essentially attributing equivalence between the power of employees and employers, this reasoning with respect turns labor relations on its head and ignores the fundamental power imbalance which the entire history of modern labor legislation has been scrupulously devoted to rectifying. It drives us inevitably to Anatole France's aphoristic fallacy, quote, "The law in its majestic equality forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread."
Thank you, Stephen. Thanks so much for reading these passages from Justice Abella. Tonia, you have the floor.
I take the points that Papa and Stephen have made. In terms of defending the protection of a right to strike under Convention 87, we don't have to reflect at length on the right to lockout of employers, such as it is. And I think it's very important to recognize that although employers' associations, organizations also have the entitlement to engage in their own administration, plan their activities, and manage their own programs for the purpose of defending, promoting and defending employers' interests, that there is a fundamental imbalance of power in the employment relationship, which obviously was highlighted some time ago by Otto Goldfreund and continues today. What I did want to say, though, is that the current compilation of the decisions of the Committee on Freedom of Association says two things. And for those who want to look at it, they can look at this. It's paragraph 764 of the compilation. And what the Committee on Freedom of Association has said, which is not surprising, is that there is a distinction between a strike and a lockout, that the basis on which they are rights that might be exercised by workers on the one hand and employers on the other is quite different. And you find that in the compilation that there are more restrictions on the ways in which employers can exercise lockouts, which can have dangerous consequences. They do acknowledge at this paragraph, which relates to case number 2530, that employers like workers can have recourse to protest action against a government's economic and social policies, which can be restricted only in the case of essential services or public services of fundamental importance in which a minimum service could be established. And I suppose what I'm saying here is that the Committee on Freedom of Association and the Committee of Experts do not necessarily, in any sense, by seeking to protect a right to strike, necessarily deny that there are circumstances in which employers could reasonably and lawfully exercise a right to lockout. But what they are saying is that the consequences are very different for workers versus employers. And I think we can all see that in context. Thank you.
Thanks so much, Tonia and Stephen and Papa, for answering this question. I have a question that I would like to pose to both Janice and Silvana in their capacity of current or former members of the judiciary, because we have a question about the nature of the case before the ICJ and the fact that many non-states actors were included in the proceeding. And this question is, do you think that having these non-state actors involved, what do you think about the balance between inclusion of affected stakeholders and judicial efficiency? Janice, you want to go first?
I think because of the nature of this ILO application to the ICJ, and considering that the ILO is tripartite, which as we know is unique, it is appropriate to have non-state actors be able to voice their view of the matter. I guess that's the best way I would put it. In a regular case, I was thinking about the law of treaties. Usually it's state to state. There's nobody else that negotiate it. But whenever you look at the ILO with the tripartite system, you wonder what's going on. Can I be blunt? In fact, in reading about Convention 87, why was the point about the right not to join a union dropped? Could have been a compromise. Well, more than one commentator suggests that there was a quid pro quo going on. So the tripartite actors at the ILO are trying to balance interests as they move forward towards a goal. That's the best way I could put it.
Thank you, Janice. Silvana?
Well, thank you. This question is actually very interesting for me because and I refer again, and I'm sorry for that, to the Italian tradition, particularly in the Constitutional Court's procedures. There is a reluctance to admit non-state actors before the Constitutional Court because the decisions are grounded on the initial litigation, because as you know, in Italy is the judge deciding a case which sends the constitutional case or question or issue to the Constitutional Court. Well, in the case I mentioned before, the one on freedom of association and the right to collective bargaining, it's one of the very few cases when a union was admitted as a party, again, not a party of the litigation, but admitted to the procedures because it was a signatory to the collective agreements which were being questioned. The collective agreements we had in front of us, the series of public sector collective agreements not being renewed and therefore being blocked and therefore infringing the freedom of association, well, that first time the union was admitted because to be a signatory to the agreement meant that non-state actor was representative of interests. The signature was the sign of its power as a signatory part. Not so formalistic. I think rather an important point to be made. This is the, so to say, if you like, strict interpretation of the Italian Constitutional Court. On the case we're discussing now before the ICJ, I think it is important to have many non-state actors. I think that gives even a wider relevance to this case. It gives strength, it offers further strength to the litigation before the court. I was actually intrigued in looking at how many there were and how they acted properly.
Thank you, Silvana. Stephen, I have a question for you, and it stems from a question that was put from one of our participants. The question from one of our participants, I'm going to read it, is: in the context of the scope of the ILO mandate, could you share insight on how the concept of dignity can serve as a foundation for the right to strike and take precedence over the economic considerations of the market? Now, regardless of what happens at the ILO, you cited the dissent from Justice Dixon. And as a matter of fact, we were discussing this dissent with my students couple of days ago in my class on collective bargaining law. It's, I think, a very powerful statement from Chief Justice Dixon. And if I recall correctly, and correct me if I'm wrong, Justice Dixon says, I'm not going to go in discussing whether the right to strike is only there to protect pecuniary interests and whether the court should protect the exercise of collective activities for the purpose of exercising pecuniary interest. What I'm satisfied to say is that strikes and the system of collective bargaining are also there to protect the rule of law at the workplace. And therefore, this is not just about the economic interest of workers. And I wonder if you could share maybe some insight about how that came about in the dissent of Justice Dixon, because I think that also is a powerful statement that we also find in the later jurisprudence of the court.
Yeah, I mean, that dissent, even before his dissent became the law in Canada, first in 2007, collective bargaining, and then the right to strike in 2015, that dissent and those passages have been cited in all manner of employment and labor law cases. But more importantly, it's actually now the majority view, or the view of the Supreme Court of Canada. The court has protected the right to strike, not only because of its importance to collective bargaining over economic matters, obviously, but also the court has looked to what it considers to be the underlying values of the rights and freedoms protected by the Charter and more broadly in international instruments, of which human dignity is one, equality is another, enhancement of democracy is a third. And they have looked to those values in informing the reasons that collective bargaining ought to be protected, emphasizing especially the extent to which collective bargaining allows workers, to come together to participate democratically in the process of determining their working conditions that affect so profoundly their working lives, and also allowing workers through collective action to refuse to work under imposed terms and conditions, which the court has explicitly said is an affirmation of the dignity and autonomy of employees in their working lives. So it has those underlying values, dignity, and others have been important in shaping the content of the freedom of association protection, absolutely.
Thank you, Stephen. Janice, I think I have a couple of questions that all boil down to the question before the court, whether it's too narrow, what happens if, based on this decision, we are left with a statement of principle that the right to strike is protected, but then there is no basically coverage of the more extensive, if you want, jurisprudence of the committee of experts. We had several questions on this, and I wanted to ask what you think about it.
It's very interesting because in 2012, the employer vice chair was a British barrister whose name I forget, because it was somebody who didn't really come to the ILO. Very unusual to be the employers group vice chair, but he attacked, of course, the committee of experts, that they were giving an interpretation this was not permissible. At the time, and I've written this, what struck me is that most of the jurisprudence on the right to strike has come from the Committee on Freedom of Association. They get the incidents, they get it faster. Yes, they are giving a decision just on a case, but it builds up. And we know that Committee of Experts looks at the Committee on Freedom of Association decisions and considers them, and I cannot think of a time when they have diverged. So it seemed odd. But it did raise the point, let's go back to 1926, that somehow the Committee of Experts was only doing technical, this word technical interpretation, And even more erroneous, by the way, is that somehow it reported to the Committee on the Application of Standards and then up to the through them to the conference. It going back to 1926, what I read, and I read all the minutes and everything. Essentially, there was too much work for the conference. The system that had been put in Part 13 didn't contemplate all this work of reading all these reports from governments. And so the conference itself wanted to delegate. Fine. But what did they want to delegate? And they saw it as two parts. One part I would put as the legal analysis of the government's reports. And the other part was a political judgment on what was going on in that country. Let's say you're doing a subject like child labor. So using the word technical, okay, if it's the 8-hour day and you're saying, well, they work 7 hours and 45 minutes or 9 hours versus 8, that might be technical. But on many conventions, and Convention 87 is not the only one. I mean, it's meaningless to use the word technical. You have to, when you use the word interpret, what does this convention mean? And is this government complying with its obligations? That is a legal analysis. And then the political analysis. Both should go up to the conference. That's my view. If that's what was designed. The Committee on the Application of Standards goes second because they're waiting for all that work to be done from the Committee of Experts. And they take it and they look at it and decide what are the interesting cases to discuss. So I just think that's wrong. But getting back to this, the status of the Committee of Experts, Papa would know more about this. There was some thought of referring a question to the ICJ about the role of the Committee of Experts. My view of what happened was it was decided not to muddy the waters on that subject, that the real issue here is the right to strike. There's a very interesting article in the most recent issue of the British Industrial Law Journal on this by a doctoral student. So I don't know if it will come up again. I can think of other cases, particularly Convention 100 on discrimination, about, what does discrimination mean? You could see, now, I've never seen the Committee of Experts attacked for observations it makes under Convention 111, but it's an interesting area. So it's not, what happened in 1926, the legal analysis occurs. It only takes me one step further. What does legal analysis involve when you have a convention that isn't that technically written, but is more generally written? Can I answer one question that came up before?
Of course.
So what happens if the ICJ either says there is no right to strike, which I hope is unthinkable, but maybe gives a narrow reading? We haven't mentioned here why the employers after 1989 suddenly, I think suddenly started to become critical of Convention 87. And my view is because trade changed. In other words, by 1989, it was evident that the World Trade Organization was going to come about. And some people on the employer side were particularly far-sighted enough to say, this will create an issue. We want trade, and we want to go to countries where we know that labor standards and labor rights are not observed. So, and we also rely on low labor costs, and we're not too keen on a vibrant labor movement in those countries that would organize and raise wages and conditions of labor. And so you start seeing it. I mean, you see it very quickly. 1994, the 50th anniversary of the Declaration of Philadelphia. Really, there's a very, very, very long section at the International Labor Conference on this. It should be read. It's very interesting. You know, with now you look back, you could see what some of these people were saying, and it keeps coming through. My feeling is the problem occurred around right after the year 2000, after these big anti-globalization demonstrations in the late 1990s. Kofi Annan at the UN started this global compact. Labor lawyers paid no attention to it because it was sort of promotional and had no enforcement whatsoever. I mean, no even monitoring, no supervisory system. But many, many hundreds of large companies signed the compact and took the labor, there's 10 principles in it, but took the labor principles and put them in their company code of conduct. The 4 labor principles are word for word what's in the 1998 ILO declaration. So they put them in their company code of conduct. As I wrote in an article that appeared in some Australian journal, they were hoist on their own petard. When they said, one of our values is freedom of association, and we expect our vendors to abide by this, did they really mean that? And since Stephen mentioned the Canadian person, I still remember that she was quoted about, a strike in Cambodia, saying that there's around the year, let's say 2012, that there was no right to strike in Convention 87. The ILO didn't have that. And why would somebody from Canada be saying that? Well, vice chair of the employers group, but also large companies buy textiles and manufacture garments from Cambodia. So the trade interest here is huge. So I look at it and say, if we don't have a strong ICJ decision on what Convention 87 means, it's going to create big issues for Convention 87. So something you don't know, Valeria, that I'm on a rapid response panel under the, I'll use the initials, Canadian, US, Mexican trade agreement, which has the ILO principles and says specifically as a footnote that the right to strike is included. But most trade agreements use freedom of association and don't expand. So you still, in all these trade agreements, you still get back to this issue of what does freedom of association mean? Does it mean nothing? Or does it mean something? Is there some international understanding on what freedom of association means? So I think the ICJ decision is very, very important.
Thank you, Janice. I think we have time for the next last 2 questions. So I will pose one to Papa and Antonia first. The question is: given the institutional crisis of the ILO, what type of legal innovation can be deployed given certain perspectives made that current laws and regulatory mechanisms governing the right to strikes are outdated in terms of their coverage of new forms of work? I think this is a question both political and legal, so I'll pose it to Papa first, and then I go to Tonia.
I will hand it over to Tonya because, as you can imagine, my focus now is on protecting what we have. But I know that Tonya and Jeff and other colleagues have worked on this, the future of the right to strike. So I will happily have Tonya answer it. But if I may, just to also a little bit add something to the question about about dignity as a source for the protection of the right to strike. I think when we were doing the research for all this work, and we were researching around colonization and the role of the right to strike and freedom of association in bringing about independence. It was very clear, especially for Africa and Asia, that the right to strike was key in asserting the dignity of workers and also the fight against colonization in Africa. Of course, this goes back also to slavery, right, and transatlantic slavery and the question of strikes there. So the role of the right to strike, the role of strikes as and activity of workers, independent the dignity of workers, is absolutely unquestionable. And in the constitution of the ILO itself, we link the principle of labor not being a commodity, right, as a key source of this concept or source of of the right to strike and dignity. I will then hand to Nyanya to speak about the feat of the right to strike.
Thank you, Papa. Tonya?
Yeah, I mean, I think that it's very important that we are not focused always on this defensive protection of a right to strike, and instead we're looking forward to think about ideally how we could use a right to strike to pursue broader contemporary objectives. So what happened over 3 years ago, before this reference to the International Court of Justice, the Solidarity Centre and the International Trade Union Confederation set up a project, and they invited the University of Bristol Centre for Law at Work to be part of that. So the three of us have been working together on a project which is really about revitalising and reimagining the content of the right to strike. So that has had two outputs so far. One is that special issue on the right to strike that you and Sarah so kindly published in the Comparative Labour Law and Policy Journal. And in there, you'll see a brilliant article by Sergio Gaminol, writing from an inter-American and South American human rights perspective on the significance of dignity and the right to strike. There's also a brilliant article there by Ruth Dukes and Angela Cornell looking at the role of the right to strike for democracy, which is of particular importance in the context of repressive, far-right totalitarian governments that we're seeing emerge across the world. But what this project does is it has set out certain academic contributions, and then we have 29 authors contributing to a book which has now been submitted to Hart Publishing called The Right to Strike Reimagined. And that will be an open access book, which together with legal materials compiled by Papa's team at the ITUC and also Jeff Voigt's team at ILO and the Solidarity Centre, will be there with materials enabling people on the ground to take action to engage in strategic litigation. In the way that, for example, Silvana did back in the day before her role as a constitutional court judge, but also, for example, the way that John Hendy and Keith Ewing in the UK have pushed these matters as well. So what we're hoping is for transformational change, not just from the top down, but the bottom up. And I think that kind of political and academic work together is very exciting, and I'm very grateful to all of you who've been part of it. Thank you.
Thank you, Tonya. And if you all allow, I will use my prerogative as chair to pose the last question to Silvana, to Professor Shara. And Silvana, actually, this question, there's two questions that I think are related. And one basically says, if strikes are allowed only when called by unions under Convention 87, does that shut out non-union workers? I want to answer to this very briefly. Convention 87 does not prevent in any form strikes called by non-union workers. The Committee on Freedom of Association has only stated that some specific legislation that reserve the right to strike to union workers may be compatible with the principle of freedom of association as long as workers are not discriminated against in forming their trade unions. But the last question that I wanted to pose to you, Silvana, is a question that asks if the right to strike is recognized as an individual right in Italy. And since you mentioned Gino Giugni, I remember your mentor saying that the fact that the right to strike is an individual right under Italian constitutional law is a dogma based on reason. Correct me if I'm wrong. I wanted to ask you if you want to comment on that particular idea of the right to strike that stems out of the Italian constitution.
Thank you very much, Valerio, because this is a point I made sure could be made in the decision I mentioned before and the ruling of the court on the freedom of association related to collective bargaining. Actually, writing in that decision that freedom of association is contemporarily an individual and collective right, meaning certainly it can be exercised individually and collectively because the individual within the collectivity of the union or the association is relevant under all I think international standards. And I think it is important that we recall this sort of bilateral, or if you like, the double phase, the double soul, if you like, of freedom of association, both individual and collective right. I think the same is true for the right to strike. In Italy, there is a discussion which is perhaps not so interesting in my in my modest perspective, which is whether having the legislator provided legislator and essential services sort of regulating the right of unions to call a strike, whether that means that the individual is less relevant now in the overall constitutional order of Italy. I don't think so. I think the individual is always relevant because the individual work relationship is interrupted because of the one single employee meaning to join the union calling the strike. But this is also relevant in strategic litigation, I think. It's important we continue to value both sides of this fundamental principle because in strategic litigation, we see now, and I was very much in agreement with what Tonya said before, making a little comparison with strategic litigation in climate change. There we see both individuals and associations being active in strategic litigation, seeking to be legitimately admitted to the procedure. And that happened, for example, in the Swiss case before the European Court of Human Rights. So I think we better stand for this, and we sort of go back to the important way the fathers, I'm sorry to say fathers, because the ones that have been quoted today are all men, Cam Freud, Bob Apple, and Gino Giugni. They both had this notion of collective autonomy, which so much encompasses in theoretical terms the notion of rights to be exercised, like we are saying today in our discussion. If I can myself put a little question to you, if there is only a few minutes left. I'm curious to know more about the role of customary international law in this discussion, because I know international lawyers, and we did go into this even in constitutional court, sort of reasoning on the role of precedents even for non-binding legal sources. They acquire a relevant role. And Janice was saying this, I think, quoting the jurisprudence of the Committee of Experts on Freedom of Association. They build up not only theories, but enforceable principles. Are we going forward on this? Are we making steps forward? And should we look very carefully at the importance of customary international law in this very strategic time of history?
Thank you, Silvana. Thanks so much for your question. Maybe, Tonya, you have an idea about this question on customary international law before we wrap up?
Very briefly, certainly we have advocated as authors in the right to strike in international law, the notion that the right to strike is encompassed in customary international law. That doesn't mean that there's consensus over every aspect of the way in which the right to strike is to be exercised, but that there is a right to strike broadly framed in the sense that you've actually said, Silvana, is something that seems to be shared almost universally. So we did see that as relevant in terms of relevant rules of international law, and it is in the ITUC submissions. But I don't think it's essential to the case. I think it is probably one of the more controversial assertions that we might make, but it is not necessary. Simply applying Articles 31 and 32 of the Vienna Convention on the Law of Treaties to Convention 87 gets us there in any case, with reference to other international legal sources, I think.
Yeah, thank you. Thank you.
Thank you, Silvana, and thank you, Tonia, and thanks again to all our speakers, Tonia, Stephen, Janice, Papa, and Silvana. This has been a wonderful panel, full of insights. We are very, very grateful for you joining us today to discuss all these things, as we are grateful to all the participants who have registered and participated. As I said, we will share the recordings of the seminar and the transcriptions in due course. And I thank again the Nathanson Centre at York University for hosting.
Valerio, I hate to interrupt, but
yes.
I wanted to point people to Janice's answer to the question about the committee of experts, the mandate question. I wanted to just point people to the resolution that sent the question to the court. The resolution states copiously the mandate of the committee of experts as agreed by consensus by everyone, and that is why, in our view, the mandate question is no more a question before the court, because everybody has agreed on this mandate. So just to add to Janice's point by referring everyone to the resolution. Thanks.
Thank you, Baba. Again, thanks a lot to all of you, all the speakers, all the participants, and the Nathanson Centre at York University for hosting us. We'll now close down the recordings and close the webinar. Thank you so very much again for being with us today.